Good morning, everyone. It's great to be here at NEBC's Managing Stormwater in Washington conference. Thank you all for joining today. Everyone in the room today is a water protector. Think about it. Everyone here is here for stormwater. We've all devoted our lives in one way, shape, or form to protecting clean water. So thank you for your work. We've got a lot of work to do. We know that stormwater is still the #1 threat to Puget Sound in terms of being the #1 source of toxic pollutants to Puget Sound. Ecology estimates that millions of pounds of toxic pollution are carried into the Sound every year by stormwater. We know who the usual suspects are: mercury, copper, DDT, PAHs, dioxins, furans, phthalates, and more. And we also are learning about contaminants of emerging concern, scrambling to catch up, really, and to figure out how to stop dumping so many pharmaceuticals down the drain. We know about the problems that these pollutants are causing, too. Coho pre-spawn mortality, which has been renamed urban runoff mortality syndrome because we know it's caused by stormwater. Our salmon are down to historic lows, with some populations at 1% or less of their historic numbers. And we know that coho can die within just a few hours of exposure to toxic stormwater runoff. Our southern resident orca whales are just at 73 right now, although we can celebrate a recent birth, so I think that number has gone up. But we know that one of the major threats to orca recovery and to their continued survival is toxic pollution. And again, stormwater is that #1 vector. We've known this for years. Toxic pollutants also hurt people. So as much as we know about the problems and the sources, we also understand the solutions. Source control, green infrastructure, simple soil infiltration, and retrofits. Jen McIntyre's work at WSU has demonstrated that filtering polluted stormwater runoff through a column of soil, compost, and sand can filter out enough toxic stormwater pollutants that 100% of juvenile coho survive. 100% survival. And how about this for a novel solution? We could stop authorizing discharges of pollutants into already polluted waters. My name is Alyssa Barton. I'm the policy manager at Puget Soundkeeper Alliance. Soundkeeper's mission is to protect and preserve the waters of Puget Sound. It's our vision that one day, all waters throughout Puget Sound will be drinkable, swimmable, and fishable. Today, I'm going to talk a little bit about the Clean Water Act. I'm also going to talk about the Clean Water Rule, and then I'll talk about the Dirty Water Rule. But because we live in such interesting times, I'd like to focus a little bit about context and opportunities. So I feel like we can close out talking about what's next. So let's get into it. The Clean Water Act. The Water Pollution Control Act, passed in 1948, was the first major U.S. law to address water pollution. But growing public awareness in the 60s and 70s led to sweeping amendments in 1972 and again in 77. As amended in 1972, the act became the Clean Water Act. I really don't think that we can talk about the Clean Water Act without looking at the context and what was going on in American society at that time. In 1960, we passed the Civil Rights Act. There was a huge cultural revolution happening. People started protesting the Vietnam War in '64 and continued protesting throughout the '70s. We had a slew of political figures being killed. We had the assassination of Medgar Evers in 1963, and then the assassination of John F. Kennedy, the president. We had the assassination of Malcolm X in 1965, Martin Luther King in 1968, and shortly thereafter, Robert Kennedy was assassinated. So we had a lot of cultural upheaval and a desire for change, and a lot of losses, both with our political leaders and the environment. There were environmental crises happening that started to get a lot more attention in the news and with the public. Rachel Carson published her pivotal book, Silent Spring, in September of 1962. Later, one of the biggest oil spills to ever occur, and the biggest at the time, happened in 1969. It was the Santa Barbara oil spill. Today, it's the third biggest spill after Deepwater Horizon and after Exxon Valdez. The Cuyahoga River caught on fire in 1969, and it wasn't the first time. It was actually the 13th time that the river had caught on fire from being so polluted. We also had folks looking at images of our planet from outer space for the very first time. In 1970, we had the first Earth Day, and the EPA was created. So I think looking big picture, at the 60s and 70s, you had so much going on culturally, a lot of upheaval, a lot of change, a lot of crisis and disaster, and people really awakening to their values around the environment. And so we had a slew of environmental bills passed. In 1970, we had the Clean Air Act. Then we had NEPA, the National Environmental Policy Act. In 1972, the Clean Water Act amendments. 1973, the Endangered Species Act. 1974, Safe Drinking Water Act. 76, RCRA. 77, more amendments to the Clean Water Act. And I think in '80 we had CERCLA too, the Superfund Act. It was such a historic moment. So many great changes were being made. I just don't think that we can separate the Clean Water Act from that important context. Despite being about 50 years old in its current form, the Clean Water Act remains the bedrock for our water protections nationwide and for stormwater regulation. So in a sense, Clean Water Act is what really brought us all here today. The Clean Water Act was meant to be read as broadly as possible, to protect as many waters as possible. We can understand that when looking at the social and cultural and historic context of the time. The Clean Water Act's single and primary objective is to restore the nation's physical, chemical, and biological integrity of our nation's waters. This objective was translated into two key goals. First, to eliminate the discharge of pollutants into the nation's waters by 1985. And second, to achieve interim water quality levels that are fishable and swimmable. Here we are today, still fighting to achieve those goals. To achieve this key objective, the Clean Water Act protects waters from pollution and from damage and destruction through dredging and filling by prohibiting the discharge of any pollutant from a point source by any person into a navigable water of the United States, except in compliance with the Act's permitting requirements and other pollution control programs. And a lot of programs were developed. We have Section 303 establishing our Water Quality Standards Program. We have Section 311, Oil Spill Prevention and Response Program. Section 319 required states to develop non-point source control programs. 402 is the NEBC program, National Pollutant Discharge Elimination System. We here all know it. That's where we get our stormwater permit. And then Section 404 provided for dredge and filling. The protections of the Clean Water Act extend to navigable waters, which the Act broadly defines as waters of the United States, including the territorial seas. The Clean Water Act's legislative history confirms that Congress adopted the broadest possible definition of navigable waters of the United States. As the conference report emphasized, the conferees fully intend that the term navigable waters be given the broadest possible constitutional interpretation, unencumbered by agency determinations which have been made or may be made for administrative purposes. The quote I just read is from the Clean Water Act legislative history, Senate consideration of the report of the Conference Committee, and it was dated October 4, 1972. The Senate Committee on Public Works was also reluctant to define the term navigable waters, based on the fear that any interpretation would be narrowly read. It reiterated that it fully intended that the term navigable waters be given the broadest possible constitutional interpretation. And why not? All waters are connected. Folks here today know about the hydrologic cycle and understand the connectivity of water. Rain falls from the clouds, it replenishes our glaciers, replenishes our rivers, our lakes. Water flows down out into the Sound. Or that precipitation comes and filters down through our soil, replenishing our groundwater aquifers, providing us with drinking water sources. The water we drink ends up flowing through us, out through our waste treatment plants and back out to Puget Sound. The water will evaporate, come back up into the clouds and start the cycle again. On, an endless cycle. All water is connected. And people are water. So people are connected to this cycle. Our bodies are made of 70% water, after all. Did you know that if you're from Seattle, your body is 70% made of water from the Cedar River or the Tolt River? You're drinking from the tap. If you live in Everett, your body is made of the Salton River. Bellingham, you're 70% Lake Whatcom water. Tacoma, you are part of the Green River. Port Townsend, the Big and or the Little Quilcene. Port Angeles, the Elwha, and so on. Never mind you people who are drinking bottled water. That's a whole other problem. Talk about that another time. But you can see how drawing distinctions between which waters should be protected can be difficult in a system that is connected. So, back to the Clean Water Act, and now, waters of the United States. Drawing distinctions. The core provisions of the regulatory definition of waters of the United States remain largely unchanged for a long period of time, from 1979 until fairly recently. In general, federal courts, including the Supreme Court, have affirmed the Act's protective reach must be interpreted and applied to waters broadly in order to ensure that the purpose of the Clean Water Act, restoring and maintaining the chemical, physical, biological integrity of our nation's waters, is fulfilled. While the Supreme Court has established that Clean Water Act protections don't extend to every single wet area, the court has consistently affirmed that EPA and the Corps have broad authority under the Act to protect both navigable and non-navigable waters that are adjacent, connected, or have a significant nexus to navigable waters. Guidance in the 80s defined WOTUS to include all waters which are currently used, were used in the past, or could be used for interstate or foreign commerce, including waters that are subject to the ebb and flow of the tide, all interstate waters and interstate wetlands, the territorial seas, all impoundments of waters otherwise identified as waters of the United States, all tributaries of waters of the United States, all waters adjacent to waters of the United States, including wetlands, ponds, lakes, oxbows, impoundments, and similar waters, and all waters with a significant nexus to a water of the United States, and then also all waters located within a 100-year floodplain of a water of the United States, and all waters located within 4,000 feet of the high tide line or ordinary high water mark of a WOTUS, and so forth. So that was regulations, guidance from the 80s. But now we can't continue to talk about waters of the United States without talking about Rapinos the 2006 Supreme Court case, Rapinos v. United States. In this instance, there was a dispute regarding whether certain wetlands on Mr. Rapinos' property, which he filled in, were subject to Clean Water Act jurisdiction. Were they protected? Were they waters of the United States? The 9-member court split 4-4-1, issuing 3 different interpretations of how to determine if a wetland should be protected by the Clean Water Act. All 3 of the opinions directly disagreed with some aspects of one another, resulting in no controlling decision or precedent. But 5 justices interpreted the Clean Water Act as protecting all waters, including wetlands, that possess a significant nexus, science-based inquiry, to waters that are or were navigable in fact or that could reasonably be so made. 5 Supreme Court justices agreed to void the rulings against the defendants who were prosecuted for polluting a wetland. Overall, a majority of the court decided that the Corps may have jurisdiction to protect and regulate waters in question in this case, but that they must further examine and justify jurisdiction in light of the Corps' discussion. So they remanded the case below to address whether the Corps' assertion of jurisdiction was supported by the facts on the record. 4 dissenting justices, led by Justice Stevens, would have upheld the Army Corps' authority to regulate the wetlands at issue outright, based on the Clean Water Act and the Corps' existing regulations. Now, following Rapinos, most circuit courts have interpreted and applied the decision, and all of the circuit courts that have applied Rapinos have either adopted Justice Kennedy's significant nexus test, or they've found that either Kennedy's significant nexus test applies or the pluralities test to protect clean water. The EPA also codified the significant nexus Kennedy approach to guidance in 2007 and 2008. So just to be clear, no circuit court has ruled that only the Justice Scalia plurality opinion provides the proper test for application of the Clean Water Act. And I'm sure everyone in the room is probably aware that the Scalia opinion was that waters of the United States rule should only protect relatively permanent, standing, or continuously flowing bodies of water. Now, what about the Clean Water Rule? Fast forward to 2014. EPA and the Army Corps began a rulemaking to redefine which waters should be protected as waters of the United States. The agencies stated their intention in the proposed rule was to retain much of the structure of the agency's long-standing definition of waters of the United States, and many of the existing provisions where revisions weren't required in light of Supreme Court decisions, etc. The scientific foundation for the Clean Water Rule was very strong. The agencies relied on a synthesis of peer-reviewed, published scientific literature that was prepared by EPA's Office of Research and Development. It was titled Connectivity of Streams and Wetlands to Downstream Waters, a review and synthesis of the scientific evidence. In preparing this science report and the proposed rule, EPA reviewed more than 1,200 peer-reviewed scientific papers, as well as other data and information, including jurisdictional determinations, relevant agency guidance and implementation manuals, federal and state reports that address connectivity of aquatic resources and effects on downstream waters, and the agencies also held extensive public comment. The Clean Water Rule was published June 29, 2015, and protected 3 basic categories of waters, or identified 3 basic categories of waters, 1, it identified waters categorically protected under the Clean Water Act in all instances. 2, it identified waters protected under the Clean Water Act on a case-by-case basis, showing significant nexus. And 3, category excluded some waters. The ink was relatively dry, and suits were filed challenging the Clean Water Rule when the federal administration changed. In February 28, 2017, President Trump issued Executive Order 13778, directing the EPA and the Army Corps to revisit waters of the United States, specifically to consider the repeal and revision of the Clean Water Rule, revising it consistent with Justice Scalia's opinion from the Rapinos case. EPA went ahead and took action, moving forward just a few months later They proposed a rule to take step one of the two-step repeal and revise process in 2017. In July of 2017, EPA proposed a final rule to repeal the 2015 Clean Water Rule and recodify the regulatory text that existed prior to the Clean Water Rule. So essentially, their first move was to get rid of the Clean Water Rule and say, we want to implement the existing rule pre-Clean Water Rule. But that didn't necessarily make sense because before 2015, the rule was derived from case law, guidance, statute, and regulation. It was a mismatch. EPA also went ahead and did a supplemental repeal rule in June of 2018, clarifying or attempting to clarify that the agencies were proposing to permanently repeal the Clean Water Rule in its entirety. Then EPA did a 2-year delay rule, trying to desperately just get rid of the Clean Water Rule. It added an applicability date to the Clean Water Rule of February 6, 2020. So they basically wanted to delay the Clean Water Rule and prevent it from being implemented until they could hurry and get rid of it. Then they issued the Dirty Water Rule. The Dirty Water Rule ultimately became effective June 22nd, 2020. And I believe that's about the day, right about the time when Puget Soundkeeper, Mi Familia Vota, Sierra Club, and Idaho Conservation League filed suit, challenging it. Called the Navigable Waters Rule, the new rule's been dubbed the Dirty Water Rule because it excludes and strips protections from a lot of the nation's waters. It limits waters protected under the Clean Water Act to the territorial seas, and waters which are currently used, were used in the past, or could be used in interstate and foreign commerce, similar to the 86 regs, tributaries, lakes and ponds and impoundments of jurisdictional waters, and adjacent wetlands. The rule excludes interstate waters from protection from the first time in the Act's history and removes protections for many tributaries and wetlands through its narrow definitions of terminology. It attempts to take away agency discretion to evaluate waters on a case-by-case basis. The Dirty Water Rule will remove protections for many lakes and ponds, excludes groundwater, and strips protections for ephemeral and intermittent waters as well. EPA and the Corps estimated, around the time of this rulemaking process, that the Dirty Water Rule will strip protections for at least 18% of the streams and rivers nationwide and at least half of our wetlands. In the process of developing both the repeal rule and the Dirty Water Rule, the agencies provided no explanation, analysis, or discussion of their science report. They didn't discuss any of the research and studies in the administrative record for the Clean Water Rule, or any of the agency findings or conclusions based on the science report and other scientific evidence. The agencies prepared no comparable analysis of scientific evidence and how various waters that will now be excluded from protection affect the ultimate goal of the Clean Water Act: to restore the physical, chemical, or biological integrity of our nation's waters. It's very disappointing that in today's day and age, the EPA, the Environmental Protection Agency, would issue these rules that are substantively and procedurally arbitrary and capricious. They're contrary to the Clean Water Act and a clear abuse of discretion. And some of you may disagree with me, but EPA really threw appropriate procedure out the window. Whether you agree with me or not, the issue is now in the hands of the court. So where do we go from here? Bear with me while I pivot a little. In her book, Braiding Sweetgrass, Professor Robin Wall Kimmerer, a doctor, biologist, enrolled member of the Citizen Potawatomi Nation, shares indigenous knowledge, mythology, and beliefs about human relationship to the land, amongst other lessons. She talks about the idea of living in reciprocity with nature. And what a wonderful and compelling idea. Whereas some folks, including myself at times, tend to view people as separate, apart, or distinct from the environment. According to Kimmerer, Indigenous peoples recognize that we are an integral part of nature. That when we love the earth and give to the earth, it will love us and give back to us in return. Folks with gardens may know a little bit about this. It's easy to feel disconnected from our environment. We're surrounded by pavement, often trapped in cars. We live in houses with walls and roofs and temperature controls. But as water protectors, I think folks in this room understand not only the connectivity of the hydrologic cycle, but the deep connection people have to the earth. Kimmerer says, knowing that you love the earth changes you, activates you to defend and protect and celebrate. But when you feel that the earth loves you in return, that feeling transforms the relationship from a one-way street into a sacred bond. What a delightful question to ask ourselves. Do you think the earth loves you back? We're currently experiencing a time unlike any other in the history of our planet. We're in a pandemic. Today, there have been almost 6.5 million infections in just the United States of the coronavirus, and over 190,000 deaths attributable to the virus. Many schools are closed or grappling with trying to reopen. Healthcare system is overloaded. Employees in many sectors have lost their jobs or may lose their jobs. Companies are facing bankruptcy. We may face a huge housing crisis in the next 6 months or a year if Congress doesn't act to pass another bailout. Stock market is a roller coaster right now and possibly in a very dangerous bubble. Countries are having to spend trillions on bailouts and medical aids. Everyone, even those not directly impacted, is at home and uncertain. And not only are we experiencing a pandemic, but we're currently experiencing a social justice movement that's been called the largest global racial justice movement in our history. That in and of itself deserves an entire keynote. I think there are clear parallels between our world today and the conditions that gave rise to the Clean Water Act and our other bedrock environmental regulations. Like in the 60s and 70s, I believe that now is a time for introspection, reflection, reconnection with our values, and action in alignment with those values. We are all water protectors. Each attendee here today is in some position of power or authority in terms of your role within your agency or company and your ability to influence colleagues or clients for the good of the environment. We could be at the doorstep of another cultural revolution. So as you enjoy the rest of your day at the conference today, learning about and building on your knowledge of the legal, technical, and scientific ins and outs of stormwater management, I encourage you to ask yourself, what will I give back? Thank you.